In this video, we're going to talk a little bit about the Colorado state law for HB 21. Welcome to the Accessibility Guide channel. My name is Sean Jordison, and let's jump right in. Now, before we jump into this important update, I want to share with you that I have an exclusive course that is self-paced in the Accessibility Guide community. This course covers an overview of the Colorado state law HB 21-1110. We begin with an overview of the law, how to develop an accessibility plan to help get your organization compliant. We take a look at roles and responsibilities and how to set that up in your organization. We look at identifying key accessibility champions from within various departments and a whole bunch of other details. If you want to get access to this self-paced course, you can go to the URL. Now let's proceed with the State of Colorado Accessibility newsletter from September of 2024. Now, I did find this article from LinkedIn, and it appears this article is written by a couple of people. One, Karen Pellegrin, who is a TAP manager. So TAP has updated the accessibility law for Colorado state and local government webpage on the OIT website, making it easier to find frequently requested information about Colorado's accessibility laws, the rules, and how to reach compliance. Specifically, the rules are intended to provide a reasonable path to compliance while also providing equitable levels of service for people with disabilities. They are not intended to hamper the availability of government services and information in any way. And here are some of those notes. We want to make sure that we are making progress, not perfection. Public entities don't have to make all of their digital content accessible overnight. However, they must show they are making progress towards accessibility. Don't remove inaccessible content. Public entities should not remove inaccessible documents and resources from their website. Instead, they should ensure that it's easy for people to find a point of contact if they need to request a reasonable accommodation, while working towards making those online resources accessible. This is also a topic that we cover in the self-paced course. Compliance with the rules equals compliance with the law. House Bill 24-1454, also known as the Grace Period Bill, is not an automatic extension of the July 1, 2024 deadline for compliance. Rather, it may provide public entities a one-year grace period to July 1st, 2025 of immunity from liability for failure to comply with the rules if that agency demonstrates good faith efforts towards compliance or toward resolution of any complaint of non-compliance. You know what would show a good faith effort? Enrolling your organization into the self-paced course within the Accessibility Guide community. Not only can you learn about this important HB 21 law, but you can learn the fundamentals of PDF accessibility, Word, PowerPoint, Excel accessibility, and universal design no matter the platform. Karen also goes on to discuss accessibility documentation and what to do with it. As part of your ongoing accessibility journey, there are a number of documents that you may be managing as part of your vetting, testing, and remediation of digital products. These could be anything from your accessibility implementation plan to product reports and accommodations plans. And for all of this documentation, you will want to have it available when needed and preferably in one place for easy access. This can help with your own internal efforts, as well as provide proof of your ongoing good faith efforts to make products accessible. Here are some of the documents you want to have and why. First, you want to have that accessibility implementation plan, and we talk about this in the course of how to set that up. But essentially, the accessibility implementation plan is the document that shows you what you know, what you have done, and what you are still working on. It's important to regularly check in on this plan and update it as things change. This is also a major element of proof that you are continuing to improve accessibility in good faith. Note, if you are leveraging the grace period and are creating quarterly reports on your progress, you can use that reporting to help develop your long-term plan. Compliance reports. As you engage vendors to procure products, apps, web platforms, software, etc., you will want to get a baseline understanding of the accessibility of that product by asking a series of accessibility-related questions and obtaining a compliance report or a VPAT. It's recommended that you obtain these reports yearly or whenever a major upgrade is made to the product if possible. Testing reports. These reports are developed through manual and automated testing efforts and show the current accessibility status of the product as it relates to WCAG 2.1 and A and AA standards. They're used to help identify and fix, remediate issues that are also good to have on file to inform internal teams on where users may need additional assistance or accommodations. Remediation reports are those that come from automated tools such as PDF reports or manual reports showing what bugs developers have fixed in websites and applications. They show what outstanding issues from testing reports have been fixed in compliance with WCAG 2.1a and AA guidelines. Accommodation plans. Accommodation plans typically outline how you intend to assist users in accessing the product based on known accessibility issues via accommodations. You can document this information using an equally effective alternate access plan, and this plan can assist your customer support and service desk teams, as well as others who assist with accommodations such as human relations, HR, and ADA coordination teams. Undue burden documentation. When a government entity does not have the significant financial or technical or administrative resources needed to make a product fully accessible, there is some undue burden documentation to state your case. This includes a description of the product, a summary of the accessibility issues, and a summary or a link to your accommodation plan. Typically, this documentation should be reviewed and updated as fixes are made, or every year. It is used as a reference to help understand the burden to making the product accessible, as well as provide proof of your ongoing efforts to improve accessibility. Apparently, there was an accessibility question of the month. Do I need to make third-party documents accessible? This is specifically for the Colorado state law. When individuals or groups outside of government provide documents that your organization has not developed or procured, this is usually called third-party content. This can be things such as contract plans from residents or builders, book reports from students, and local contest submissions. Third parties sometimes post content on state and local government websites or mobile apps. Third parties are members of the public or others who are not controlled by or acting for state or local governments. The state or local government may not be able to change the content of a third party's post. And there's a fact sheet, a new rule on the accessibility of web content and mobile apps provided by state and local governments by the ada.gov. Documents submitted by the public or individuals outside of government entities do not need to be made accessible. When an employee of the public needs access to these documents after submission, the government entity can choose to remediate the document at that point or provide another reasonable accommodation. However, if the government entity that takes that third-party documentation and rolls it into their documentation, then they're taking ownership of that document and therefore needs to make it accessible. I don't love this rule. I've got to be super honest with you. I feel like any documents submitted by the public or outside the government do need to be made accessible. If they are posted online by the government entity, in my opinion, they should be made accessible, whether or not they came from a third party, because this creates a very slippery slope. Where what if I just pretended to be a third party and I posted a whole bunch of inaccessible documents? That is not like a way to get out of this. I highly recommend setting up a system, and we talk about this in the course, of how to get your documents from inaccessible to accessible prior to posting. That concludes today's brief update on the Colorado State Law HB 21. If you want to deep dive into the law and how to help your organization get accessible, join the Accessibility Guide community and take the Colorado State Law course that I have developed. And if you want to find out how I can help you get accessible, there's a link in the description for that too. And as always, I could be your champion for inclusion. Thank you so much for joining me today, and I'll see you next time.